Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you kindly, Jill. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right and your left is Judge Walsh, and to my left and your right is Judge Toone. And we will be the panel for the 5 cases this morning. I suspect that we'll hear 3 cases, and then we'll take a short break before coming back and hearing the final 2 cases for the day. I can tell you that we've read your materials and familiarized ourselves with the facts and the lead cases, and so you need not go over those things unless you like. Of course, you can use your 15 minutes in any way that you'd like. There's no rebuttal, so use it as efficiently as you think is warranted. And with that, we'll call the first case, 23P1334, Commonwealth versus Kenneth Dwyer, and Attorney McKenna.
May it please the Court. James McKenna for Mr. Dwyer. Good morning.
Good morning.
This is not a Hallinan case. This is a wannabe Hallinan case. Mr. Dwyer tried to bring a claim consistent with the principles in Hallinan and didn't get there. The only matter reached by the Court was the question of waiver. And we would suggest the Court erred with respect to waiver because at the time of the plea in September 2016, the only thing at issue were internal source codes for the breathalyzers or questions about calibration. The intentional egregious prosecutorial misconduct did not occur, was not revealed until 2017.
The issue as to the accuracy of the machine was being challenged at the time of the plea.
Yes, sir. Absolutely, sir.
Okay. And we didn't know how that was going to resolve one way or the other. Is that fair to say?
Absolutely, yes, sir.
But we knew that it was being questioned and challenged.
Yes, sir.
And so 50-50 chance that maybe it's not going to be deemed reliable.
Yes, sir.
Okay. And your client knew that?
Yes, sir.
Okay. Your client was in custody at the time?
Yes, sir.
Anxious to get out?
Very much so.
Very much so. Okay, go ahead.
And if we had brought a claim saying that there was a problem, if that 50-50 chance worked out so that there was an establishment of fact that the source codes, as was discussed in 2013, or the calibration issues were unfavorable, and everyone would get a new trial based on that, we'd have no argument. We'd lose.
But he knew that was a chance.
And that's what was waived. We didn't waive what wasn't known. We didn't waive a claim based on the intentional misconduct. And that was brought by the intentional misconduct and the egregious misconduct, which was defined in Hallinan.
Isn't the end result the same?
It might have been the same, yes, Your Honor. But a claim based on intentional misconduct would differ materially from one based on an error in the source code or failure to calibrate. And that's why Hallinan came out as it did, where the court said because of this misconduct, this egregious misconduct, this failure to disclose exculpatory evidence, all the convictions go away. And based on that newly discovered evidence, we brought the claim, actually we brought just before Hallinan came out, the same argument as defined in Hallinan. And that's why the waiver argument wouldn't work. The waiver decision was error, Your Honor.
So I'm trying to completely understand your argument and help me here. What should have the trial judge said or done other than agree with your motion, but at the time of the plea?
At that time, the judge should have rejected any question about waiver and gone right to a Hallinan-type analysis, applying the Scott-Ferrara test as to whether Mr. Dwyer would have waived would have pled guilty or not, gone to that analysis, but that was not reached.
No, you're talking about the hearing on the motion to withdraw the plea, but
Yes, sir.
I think Judge Walsh was asking about what should the judge have, accepting the plea, have done differently. Because the judge warned the defendant, said, listen, there's this case, pending challenges, it's challenging, could affect the results of your breathalyzer test here. What else could the judge have done to put the defendant on notice to get away from what you contend is a waiver?
There's really nothing that could have been done, because this was exculpatory evidence, newly discovered evidence that was not discovered until 2017. So in 2016, the judge couldn't have asked if.
But so I guess and Justice Desmond asked this earlier of, would it have mattered? But in some instances, does the judge or the defendant need that level of specificity? In other words, the judge kind of identified there is a potential issue with this breathalyzer machine. And whether it was generally prosecutorial misconduct or whether it was that the machines had a faulty part in them and nobody knew, right? Or anything in between, the judge identified a potential problem with reliance on the breathalyzer results. Your client heard that there may be a potential problem, regardless of what that level of specificity is, and said, okay, I get it. I want to get out. I want to take the plea. And so why does it matter the specificity of the exact nature of the issue since it was identified? That's, I guess, my question.
Thank you, Your Honor. I would say the difference is it's not a defective machine, but Hallinan turned on prosecutorial misconduct, which was unknown. And that's the material difference, that it's not just a machine being broken in a different way or not working in a different way, but the fact that this egregious misconduct, intentional misconduct took place and was not known at the time of the plea.
So why doesn't the general colloquy, leave aside the separate colloquy that focused on the OAT, but why wouldn't the general colloquy on all motions that you may or may not have had, all motions that you had discussed, you're waiving all of that, why wouldn't this fit into that box?
Thank you, Your Honor. That goes back to the Scott case, perhaps, the 367 mass. We rely on that as half of the Scott-Ferrara test. And the allowance in 2014 of the motion to withdraw in that case, based on the newly discovered evidence relative to the Hinton Drug Lab, would be the answer, I would suggest. Newly discovered evidence discovered after the general colloquy was not deemed to, was the basis for Scott's decision in Scott. And that same type of analysis would apply here. Newly discovered evidence of intentional misconduct would form the basis for the motion.
I think we understand the argument.
Thank you very much, Your Honor. And at the risk of sitting down with 8 minutes to go, I'll do that unless there are further questions. Thank you.
Thank you kindly. We'll now hear from Attorney Palumbo.
Good morning, Your Honors. May it please the Court, Karen Palumbo on behalf of the Commonwealth. The defendant in this case, as the Court already noted, he explicitly waived his right to challenge the breathalyzer test. The prosecutor knew about it. This information was known at the time. The prosecutor asked the judge to inquire as to whether he was aware of this challenge to the breathalyzer test. He did so, and the defendant said, correct, I am aware of it. And he wanted to plead guilty regardless. The Court already noted he wanted to plead guilty because he was incarcerated. He had defaulted, and on the 31st of August was picked up on the 7th of September, and he was still in custody on the 15th.
Did he get a favorable disposition at the plea?
He did. So it was an OUI second, and the minimum sentence for that is 60 days in the House of Correction, and it cannot be suspended to less than 30 days. The defendant received a 2-year suspended sentence. 90 days to the House of Correction, suspended for 2 years. So he avoided jail time by accepting the plea. And the other charges were dismissed or found not responsible. A big difference between this case and Hallinan is in Hallinan, for the motion for a new trial or to withdraw the guilty plea, plea counsel filed an affidavit in which he stated that because of the BT, which was .23, it was the crown jewel of the Commonwealth's case, he advised his client that it's not cost-effective or time-effective for us to take it to trial because the BT was so bad. And there's another case, Schnupp, which was a similar thing. There was an affidavit provided which said that he said because your BT was 0.18, you're per se intoxicated, so the Commonwealth doesn't need to do anything further than that to convict you. With this case, there is no affidavit from plea counsel, and there's no assertion even.
There's no affidavit from plea counsel in this case?
No, there isn't. Plea counsel was not the person who filed the motion for new trial.
Oh.
But he wanted to get out of jail was one of the reasons.
There is an attorney affidavit in this case.
The attorney affidavit is the motion counsel's affidavit, and she represents that she spoke with plea counsel. And what plea counsel said is concerning, but doesn't have anything to do with the breathalyzer test. The defendant really challenges the withdrawal of the plea because he thinks it casts real doubt on the justice of the conviction. And he says that because he doesn't believe the officer's observations. He disagrees with them. Well, whether or not he agrees with the officer's observations, that's a question for the jury. It's not a reason to grant a new trial.
Ms. Palumbo, can you just briefly address Mr. McKenna's distinction between a potential problem with the breathalyzer and the finding of egregious misconduct? Is that an issue here?
So Hallinan means that this defendant, when he filed his motion, although Hallinan hadn't been decided, should have been entitled to a conclusive presumption of egregious government misconduct. But the defendant still has to prove that that evidence casts real doubt on the justice of his conviction. Sorry, I lost my train of thought. He knew, I'm sure you've read this already, but the trial judge asked, Mr. Dwyer, you understand that your case was dependent or attached to some litigation pending, challenging the results of the breathalyzer test. And you understand that by pleading today, you're giving up or waiving any rights you may have under that motion, correct?
Right.
And also with waiver.
I understand the argument to be, well, yes, I waived the challenge to the results, but I didn't know there was going to be a finding of egregious misconduct, and that's not something I'm going to waive my rights to assert. So do you have any thoughts about that?
So, well, yes, the egregious government conduct, but again, well, first off, the doctrine of waiver is not so narrow as to require a decision that is squarely on point before a claim is deemed sufficient. And I would say it was. They're challenging the accuracy of the breathalyzer test. Nobody knew that there was going to be the extent of the withholding of documents. That was just not known. But there was an issue with whether or not the breathalyzer was accurate. Nothing in his plea or in his motion suggests that his plea was motivated by the breathalyzer results in this case. It was motivated by his desire to get out of jail. So I would suggest that the motion judge who was also the plea judge, by the way, so he's well-versed in the facts of the case. He did not abuse his discretion, nor did he commit an error of law by deciding this case on waiver. However, I would suggest that there's overwhelming evidence regarding this individual's intoxication. Therefore, even given the conclusive presumption, there's no doubt in my mind that this conviction was, that information casts doubt on the justice of this conviction. Again, a favorable plea. Also, one thing, if the court were to remand this, or...
Would they be bound by the offer?
I suggest no, because it's an illegal sentence, and that was also the case in Hallinan. So we would not be capped at that sentence if he were to either go to trial or plead out again. So if the case is remanded, you could also remand it to have him make findings as to whether that information casts real doubt on the justice of the conviction. But I think waiver was sufficient. It was explicit, he was asked, he agreed, and the BT did not motivate his decision to plead guilty. So for those reasons, I would ask that the court affirm the motion judge's denial of the motion to withdraw the guilty plea.
I know I've read it, but I think I'm getting my facts confused, to be honest with you. What was the BT reading in this case?
It was .14.
Okay, and so your distinction of Hallinan is the crown jewel of the .23 was...
And in addition to that, that the motion to withdraw, the attorney specifically had told her that with that BT, it's not cost effective and it's not time effective to go to trial.
Thank you.
Okay, thank you. Thank you, Your Honors.
Thank you. Very well argued on both sides. The matter stands submitted. Our next matter is 23P1398, Commonwealth versus Eddie McLoy. Morning, Attorney Green.
If it may please the court, Bruce Green on behalf of the appellant, Eddie McLoy. This is a drug possession case, and I want to start by saying a rule of law that mere presence in a place where drugs are being kept is not sufficient to sustain a conviction for possession of those drugs. It's certainly my position that that's what this case is about, is mere presence. And if there is presence, there can be situations where there's other plus factors, so to speak, that can indicate that it's more than mere presence. And in this case, there were certainly two co-defendants, and there were plus factors for those defendants. And I think that's relevant in this case because when there is a situation where there is contraband of some sort, and there's only one person, I mean, somebody owns it. This is a case where I think there's a lot of evidence that two other people possess this, and not my client.
You agree circumstantial evidence alone can be enough to convict?
I'm sorry, did you say?
You agree that circumstantial evidence alone can be enough to convict?
Absolutely. I don't think there is circumstantial evidence in this case to support such a conviction. I mean, in other cases, there's things like indicators of residency in the location, which is circumstantial, but there is no such indication of residency for my client in this case. There certainly was for the other two people that were charged.
So I appreciate your advocacy, but considering the fact that the facts are viewed in the light most favorable to the Commonwealth, do you concede or agree that there are any plus factors for your client?
I do not.
Even in the light most favorable to the Commonwealth?
Yes.
There's nothing other than mere presence is what you say?
Correct.
Okay, tell me why.
Well, he was present, and the evidence shown at trial was that he was being led out of a room where there were drugs present, okay? That's, I'm going to just suggest, somewhat ambiguous as to when or how long or where he was, what he did in that room. And the cases that hold where presence is enough also rely on things like residence, and there's one of the cases the Commonwealth relied on was Proya, where...
Rosario, right?
Well, Rosario is one of the cases as well, and and that was an unpublished decision, but it was a situation where the defendant was laying on a bed, and the court conclusion was that he appeared to live there. And in many of the cases, the word they use is that the defendant occupied the premises. So there is no such evidence in this case. He was certainly present, but unlike the other defendants, no indications of rent receipts or things like that.
Sure. This was a jury-waived trial.
Yes, it was.
And there's some evidence that the police had to breach the door of the room that he was found being let out of.
Yes, the officer that testified said that he had heard that they had to break the door down. And I know there are some other cases where they talk about a heavily barricaded location, an apartment where wood is nailed across the doors and things like that.
And in the room that they had to breach, where he was the sole occupant at 8:30 in the morning, was the room that contained the monitors to do the surveillance outside the house, the safe that had the guns in it, the dresser that had the drugs in the top drawer and on the top of it. It was really kind of the central location, would you agree, of the drug operation?
Well, I don't know if it was central. There were certainly other spots in the house, in the kitchen. There was stuff.
Of the house. The house was a drug house, essentially,
Yes,
right?
there's no question that location was a spot where people were selling drugs or being used for that purpose. But again, what was my client's connection to any of that other than being there? There were no drugs in plain view. They were in dresser drawers. And there was a safe that had a different person's fingerprints on it that was in a closet. And again, his knowledge is not enough either. It needs knowledge, it needs ability to exercise dominion and control, and intent to exercise dominion and control. There's really nothing in the record to indicate what he was doing in that room. Well, the only evidence produced was that he
What
was
can we
being...
infer?
Can I
What's the
go,
reasonable inference that he was doing in that room?
and can I back up for a moment? You just stated there was no evidence. And in the light most favorable to the Commonwealth, unless I'm reading the record incorrectly, on top of the bureau, there were digital scales, a cutting knife with residue, and boxes of baggies, right? I mean, this is not
Yes.
just a makeup mirror and some lipstick on top of a bureau top, right?
No,
Stated to Justice Desmond, there was no evidence at all. Everything was in drawers and in closets. I don't read the record as
Well,
you do.
I think what I said was there was no drugs in plain view. Certainly there were scales with residue and that sort of thing. But the drugs that were found that were the basis of the charges were in drawers and in the safe.
If we think there's enough evidence here to support a finding that this room was sort of the central location of a drug operation, what do we make of the fact that your client was locked in the room by himself? Is that, I understand the principle of mere presence is enough, but being present in a room where there's a drug operation going on and the door being locked, are those factors that we can't consider in establishing, as sufficient to establish constructive possession?
Well, I'm going to suggest that the evidence presented as to my client's presence in that room in this case, I'm going to say is a little unusual because the way the evidence was presented, the officers that actually entered the house and would have had the best indication of who was where and doing what, didn't testify in this trial. And the only evidence that they broke the door down was hearsay. The officer testifying said, I heard that they broke the door down. So I would say any inferences as to what he was there for, how long he was in that room, what he was doing in that room, become very speculative. Yes, if you want to draw the inference that he was sleeping in the room, he'd been living in that room for a few weeks, sure, then that's a pretty good plus factor. But there is nothing to support that, in my opinion. And there's...
Does that help? I mean, does it help your case if there's no evidence of him actually living there? I mean...
I believe it does, because there is strong evidence of other people living there, and residency in the place where the drugs are found has certainly been a plus factor in a lot of cases. And so there isn't any. And, you know, he has no money in his pocket, and one of the other co-defendants does, and that's certainly been a plus factor in a lot of cases. So...
What was he doing there? He was just visiting? What was he doing there at 8:30 in the morning in the locked room that the police had to breach in order to get him to come out? What was
Well,
he doing?
I think
What's the reasonable inference from that?
I think the strongest inference is that he was a buyer. I mean, this is a place where drugs are being sold, and I
Did you
know.
leave a buyer in a locked room with all the drugs by himself?
Well, again,
Is that reasonable?
because we don't know what transpired when the police entered that apartment, whether he was left in that room by himself, as you're saying, or he perhaps ran into that room because the police were entering. We don't know, and that evidence wasn't presented. So was he a buyer that went to the apartment and the police came in and he went into that room and locked the door? I think that's a fair inference. I think trying to infer more than that on this record is speculative.
But we don't have to infer that he was coming out of the room.
That's correct.
But in your scenario, we have to infer that he had just recently went in the room.
Well, there's just no evidence as to how long he was in that room, one way or the other. So, I mean, lots of inferences could be drawn, but that evidence wasn't presented. So on this record, I think, and there are some cases that talk about, I mean, one gentleman who lived with his, I think it's the Frangillo case, lived with his fiancée in an apartment, and the court said, okay, his clothes were there, the landlord saw his car coming and going, but we don't know how much time he spent there. So
There were some monitors in that room that were surveilling the outside of the building or the structure, correct?
Correct.
Let's say his job was to just do the surveillance. Could he be hooked for possession of B with intent?
Well, that would be a very strong joint venture case. And I know there was one case I did read that I sort of didn't discard it because it was a joint venture case.
This is a joint venture case, isn't it?
No, this is a constructive possession case.
Possession or possession with intent?
Well, the charges were possession with intent, so
It started as trafficking.
I believe so.
He was found not guilty of the guns in the safe.
That's correct. I mean, to me, there's a little bit of an inconsistency, but to the point of whether there's enough.
So back to my question. If his job is to just monitor the surveillance videos, is he a joint venturer?
Well, if that's his job and that's what he did, then yes, I think that's a strong case for joint venture. Whether that's a strong enough case for his ability to exercise dominion and control over drugs that belong to somebody else, as I think there is a lot of evidence of that in this case, I don't think it supports that.
If you're in a room with the drugs by yourself, who else has ability to exercise dominion and control of those drugs?
I would say the people that own them.
Even if they're not in the room and you're in the room by yourself with the drugs?
Well, I guess what you would be asking me is, does he have the ability to steal the drugs?
Or does he have the ability to exercise dominion and control of the drugs, is what I'm asking you.
I don't know, I would think I wouldn't say that's a strong inference. Because I don't know, I would just say it's been my experience as a criminal defense lawyer that people that do own the drugs are somewhat possessive about it, to the point of killing people. So it is not just the ability, but it's also the intent. So if there's someone else's drugs, even if you could go over and pick them up and take them, you might not want to because there will be consequences to that. So.
Are we to make anything of the fact that he had been seen with the other two, or at least with two other people who I think occupied that house or lived in that house, at some earlier date?
Well, I would say no, because I think that supports the inference that he's a buyer equally as anything else. I mean, lots of other people came to that house according to the testimony. So I don't think that we would say all of them must have owned this or possessed these drugs either. I mean, if he's a buyer, that's what him and all the other buyers do, is go to that house. So no.
The evidence of he was a buyer.
I don't have anything to say to you other than that he was there. He was seen there coming other times, which is what buyers do. But I'm going to say that's sort of shifting the burden on its head.
No, I was just asking you,
Yeah.
because you seem to represent that he was as much a buyer as anything else, and so I'm trying to figure out what the
I'm
reasonable
just
inference is.
saying that's a plausible inference.
And I'm asking you why.
Yeah, well, the fact that he didn't have large amounts of cash on him, and that was the testimony that typically the people selling drugs do have large amounts of cash on them, and he...
People buying drugs usually have money to buy them, right?
Yes, and the evidence, if I remember correctly, was that he had nothing significant in his pockets. So perhaps he had enough to buy drugs. I mean, that was what we're left with. There wasn't an accounting in the record of, he had no money, just nothing significant. So it's certainly plausible that he was there as a buyer. So if there's no other questions, I'll rest on my brief. Thank you.
I think we got it. Thank you, Attorney Green. Now I'll hear from Commonwealth, Attorney Kennedy.
May it please the Court, good morning, Your Honors. This Court should affirm the defendant's conviction. The judge correctly denied the defendant's motion for a required finding of not guilty, where the evidence in this case, when viewed in the light most favorable to the Commonwealth, established that the defendant constructively possessed the heroin and cocaine with the intent to distribute it. As my brother has pointed out, mere presence alone is not enough to show constructive possession. You have to show knowledge plus ability and intention to exercise dominion and control. And as this Court has already pointed out, the circumstantial evidence and the inferences to be drawn therefrom were sufficient to show that the defendant was guilty. Here, I just wanted to address a couple points that counsel has made in this case. The Court has pretty much pointed out a great deal of the evidence that I've already set forth in my brief, and I don't want to repeat it unless the Court has questions on that. But two pieces that counsel keeps reverting back to, I think, need to be addressed. First, he said that it was clear that someone else, quote unquote, owned the drugs. Drugs, in this case, possession of the drugs can be joint. It doesn't have to be one person or another. And the possession can be if you have the ability to exercise dominion and control over those drugs. If you are found in the locked room where the only drugs in the house are located, and it is over $20,000 street value of drugs, with surveillance cameras, with contraband in plain view, indicative of only distribution. And given the fact that there was expert testimony that this wasn't just your average street dealer, but a local dealer controlling a larger geographical location, there is no way that defendant was in that room unless he possessed those drugs, because as this Court pointed out, he's not going to be allowed in that room if he's just a buyer. There was no evidence in this case that the defendant was in fact a buyer, and when you take the inferences in a light most favorable to the Commonwealth, it is clear that he possessed these drugs with the intent to distribute them. If the Court does not have any questions...
Can you just, Mr. Green said that the evidence that the officers broke down the door was hearsay. Do you agree with that, or do you disagree with that? Was there competent evidence to establish that point, or that the defendant was locked in the room?
What Trooper Dolan testified to was that he believed that the door was locked and that the stop team had to break the door down.
Okay.
There was no objection to that testimony, so that is, in fact, fair game when assessing the sufficiency of the evidence. And when viewed in a light most favorable to the Commonwealth, there was no other evidence suggesting it was not broken down. So therefore, the evidence is that the door was locked and that he was behind this door.
And how much of a difference does that make to the constructive possession analysis, the fact that he was inside a locked room like
I think that makes a significant difference in this particular case. I think when you add in the fact, too, that this was the operations room, maybe if the door wasn't locked, I could still make the argument. I think it helps me, I think is a better way to say that. But given his location in the operations room, it's just not plausible to believe that he would be in there on his own, that he ran in there as a buyer. And as this court has pointed out, there's no way he ran in that door. If he was a buyer, where's his money? There's no tools in there indicative of use. There's nothing. So to me, the fact that he doesn't have money helps our case. He's not in there to buy. He's in there working. He's working with the crew to sell drugs to different people.
This is at 8:30 in the morning.
At 8:30 in the morning, yes. Does that answer your question?
Yes, thank you very much.
Okay, thank you. If there are no further questions, the Commonwealth will rest on its brief and ask this court to affirm the convictions.
Matter stands submitted. Thank you both.
Thank you.
Next up on our list is 23P0929, Commonwealth versus Salvant. So, I want to say arrest, but I'm not quite sure how to pronounce your last name.
Arreste, thank you.
Sure. We'll hear from you first for the appellant.
Thank you. Good morning, Your Honors. May it please the court, Attorney Arreste for Mr. Salvant, the defendant and appellant in this case. This is a case with two, I would argue, two equally important issues on appeal. And the first I would like to discuss is the issue of a Batson-Soares violation. We're arguing on appeal that the judge erred in delaying the analysis of the Batson-Soares challenge and also erred in finding no violation. Juror 27 was a young female minority of the same racial background as the defendant.
What does that mean? What does that mean?
Juror,
What is the racial background? What is that?
so I knew that question was going to come up. So I would say we're arguing on appeal that the record was preserved, that the counsel in doing the Batson-Soares challenge stated that this person was of the same racial background as the...
I don't know what that means. What is that racial background? I don't know what that means, so I need to know what that means. What racial background is it that we're talking about?
Well, I would say based on the exhibit, Mr. Salvant is clearly, of a minority background.
What minority background is he?
Well,
Sorry if I'm not being clear. I need to know what that is. You show me a picture of a guy who looks like he's brown.
yes.
So what does that mean?
We would say that he is African American at this point, but I think the record...
Anything in the record that supports that he's African American?
I think that the record supports that the defense counsel says he's a minority protected under Batson-Soares, and I think if you look at the case law, it is challenging with Batson-Soares because we don't currently keep all the records of the jury cards. And I think if you look at case law, if you look at Concepcion, which was a 2020 case, unchallenged assertions of counsel regarding jurors' group memberships are deemed established. And here we have that the counsel, it wasn't challenged. We have Robertson that tells us under a Batson analysis, the judge ought to presume that the juror is a member of a protected class at the time at issue. And then we have Cosable, which is a 20...
We're, I hope, pretty well aware of the case law when it comes to Batson-Soares challenges, and I appreciate the thoroughness. But when we get back to exactly what and when, you kind of come out strong out of the gate saying this was delay by the judge. And I see on page 100 of the transcript, Your Honor, I challenge a peremptory challenge so that this is, and then there's inaudible, as we have no idea what was said. I know the jury, now this is just after the Commonwealth had for cause challenged.
Yep.
We let the Commonwealth show bias, inaudible, young minority female trying to sit on the jury that has experience, and I just, inaudible. You want us to assume from young minority female trying to sit on the jury that has experience that this is, Judge, this is a Batson-Soares challenge right here. You need to do the analysis. The way that I read the transcript, it wasn't until the jurors were excused, after 3 more were picked, and the attorney says, I'm not sure the microphone really picked up on my argument, but I want to let you know, Judge, that way back when I did a Batson-Soares challenge, you never put anything on the record.
Yes, so I would.
First time, right.
Yeah. Well, I would argue actually that when he's allowed to speak, which is page 120 of this transcript, he does say same background as defendant. So I do think he does put that on the record.
But page so let me just finish that thought. So at page 120, when he says same background, so it's a little bit, I guess, closer than we have a young Hispanic female who's just trying to sit on the jury. That's all we get. Then we get same background generally, and I'm not sure again because I don't know what that means, but assuming that it's not an onerous standard, what's the judge to do? He's already excused the jury. We may or may not have this juror still back in the jury pool. Before the jury ever gets in, he goes through the whole Batson-Soares analysis.
But that's
So what?
That's the problem. He erred in not doing it contemporaneously.
Where's
So
the harm, though? He did it. Now, he did it.
the juror's gone. There's technically no remedy at that
Well,
point.
first of all, how do we know the juror's gone? We know that the juror isn't in the room. Secondly, there's always the out of a mistrial, right? If, for some reason, if the judge found that the reason wasn't genuine and adequate, which we need to address, but the record doesn't establish that the juror is now gone and gone on their way. The way I read the record is that you go with the court officers. Could be in a jury pool room, could be wherever, but regardless of that, as soon as the defense clearly said Batson-Soares, the next thing the judge did after taking the lunch recess is provide the analysis. I don't see that as a delay. Tell me where I'm wrong on that.
I think that on page 100 and the conversation that happened once the jury was gone before lunch, I would say defense counsel contemporaneously multiple times voiced his objection and concern.
On his own, at page 100, you think that was sufficient to establish a Batson-Soares challenge?
I think he says, Your Honor, I would challenge that peremptory challenge.
You think by saying, I would challenge that peremptory challenge is enough to put the judge on notice?
Yes.
This is Batson-Soares.
And he says young minority female that wants to sit on the jury. The court interrupts, doesn't let him be heard. He doesn't let him have an argument at that point. He doesn't do an analysis that, never mind getting to the analysis, he cuts. I would say if anybody is at fault that this was delayed, it's the judge because he didn't allow counsel to be heard. He shut him up several times during this trial, including on the Rule 14 violations, but definitely here, thank you, denied, declined to engage further. So I would say that the defense counsel had to then press again after the jury left the room and say, Judge, Your Honor, we haven't addressed this. And he declines, takes lunch, comes back. Maybe during lunch he looked at Batson-Soares. Maybe he did some research.
What's the harm?
The harm is that
even if it was delayed, so accepting the fact of your argument that it was somewhat delayed, not contemporaneous, that was enough to start the Batson-Soares, and the judge didn't. So?
I think the harm is multiple. I would say that the challenges should be evaluated immediately because you're thinking about what's the harm to the defendant, but I think that we also see case law say that the juror had rights to be seated on the jury.
Well,
so
you're in no position to challenge for the rights of the juror. What difference would it have made if she had still been there?
if she had still been there, this is what's important. If it's done contemporaneously, the judge can evaluate in the moment. He can observe.
What difference would it have made if she had still been there?
He could have further questioned her in deciding. He had already found her impartial and unbiased, but he could have further questioned her.
Is there anything in the record that suggested that he wanted to further question her?
But he could have, but he didn't
understand.
because
I
she wasn't
understand.
in the room. And also, I would argue that a contemporary, no prosecutor's ever going to say, I'm using this parametry because this person is the same racial background as the defendant. So if you don't immediately challenge and question the prosecutor on the preemptory, you're not going to be able to truly evaluate the genuineness of their response if it's hours later.
This is a woman who said, Judge, you were the same judge on my OUI case. You were the same judge where I got convicted and I had to do some probation. I mean, all that came out before the challenge, right?
Yes, and he had questioned her, and he had said, will any of that impact you? Can you be
All
unfair?
that came out before the challenge.
Before the challenge, and he used, and the prosecutor used that she had that same legal situation. She may have been in front of you at some point during that case as their for-cause proffer, and that for-cause proffer was denied.
Hold on. So I think the record supports that he asked for a for-cause challenge.
Yep,
Judge denied it.
yep.
And the judge said, but I know you have one peremptory left. Would you like to exercise it?
Yeah.
Right? That came from the judge.
Yeah,
And the prosecutor said, I would like to exercise my last peremptory.
yep. And the defense immediately challenged it. The analysis was not done as case law says it should have been.
Can I interrupt for a moment? When Justice Desmond asked you about what difference would it made if the juror was there, Batson Soares doesn't go back to the juror's racial makeup or bias. Batson Soares is challenging the prosecutor's motive for taking a juror and removing a juror based upon a protected class. So whether the juror is right there in the audience, in a jury pool room, or out shopping at Macy's, what the inquiry that the judge is required to do, which in fact the judge did, is to say, give me your genuine and adequate reasons, and then I make an independent analysis of whether I agree. Not to call juror number 29 back up here and to figure out all these things. It's to say, what's motivating the prosecutor? So I don't understand the response of, well, if juror 29 was here, we could have had some more inquiry. That is over. This is not for cause. This is that peremptory to make sure that the prosecutor's motivation isn't based upon a protected class. And so wherever juror 29 is, I don't see how that's relevant at that point in time.
I think it's relevant in this case because the proffer that the prosecutor made in giving a race-neutral explanation for the preemptory was because they were worried about that person's bias. And I think the judge had asked at length, had an at-length, find them impartial.
And the judge could say, well, that's not genuine.
But if the analysis had happened contemporaneously and the judge had just said, hey, I question that juror at length and found them impartial and unbiased, and now I'm denying that. I'm not saying for-cause and Batson analysis are identical because they're not, but one is relevant. And if they had done it contemporaneously and the prosecutor just repeated the same thing they had just said for cause, the judge would hopefully have said, I need more than that. I just told you that I found her impartial and unbiased. I know what you're saying, but he would question whether this was race-based in the moment versus an hour and a half later. When he came back from lunch, he didn't even really remember what juror they were talking about. He said to the defense counsel, is it 27? I gave my cards away. So when you look at the Jackson case and you look at the analysis and the reflection that case law is asking the judges to do during Batson Soares, did he evaluate the composition of the jury, whether the victim was a member of the same protected group, any similarities or differences between those excluded? I don't see any of that being done here when the analysis was finally done.
Would you agree that it's not uncommon for the government to move to challenge somebody for cause and that be denied, and then they exercise a peremptory? Or either side, it doesn't even have to be the Commonwealth. Would you agree that lawyers routinely move for cause to have jurors excused, and when their cause is denied, they exercise their peremptories? Is that uncommon?
I don't think it's uncommon, but I think it's relevant in a situation where you have a Batson Soares challenge and you have a juror who's of the same, presumably of the same racial background as the defendant.
I don't know what that is. Presumably they're both brown, so that makes them both protected class, from what I understand your argument to be. I don't even know what that is, right?
That's our argument, is that they're both in a protected class, yes. And I don't think it was challenged, and I think the record preserves it. I would just quickly, I know we focus a lot on bats and sores, and it's a super important issue, but I think there was a major discovery violation in this case that's just worth a couple minutes. And there was undisclosed evidence that came in, and those were statements against interest. And not only was that automatic discovery, because in 2004 the rule was updated to include automatic discovery, any oral statements made by...
Okay, so had the defense attorney known that the Trooper Murphy was going to say, yeah, he admitted to having a few drinks, what would he have had now that he didn't have available to defend his client? So in other words, the argument that I see in your brief is that, well, he could have called his passenger. He could have called his passenger anyhow.
But there was no need to if he didn't know that there was statements coming in that were against his interest, saying he was at a family party versus, you know, something he could have had a witness come in to say. I think looking at it that way says, why do we have rules? Rules are only, Rule 14 is only applicable if it would have made a difference. I think this was a case where the defendant motioned to the court, made multiple requests, went in 2001 and got a court order for discovery. This is an OUI case. A statement of a defendant saying, I ingested alcohol earlier in the day is bombshell evidence. At the start of the trial, the prosecutor said...
Let me interrupt. Not really bombshell in this case, because your client got found not guilty of the OUI, so you've got to show to us that on the neg op, the statement that we all agree should have been provided, absolutely should have been provided, should have resulted in a mistrial for the neg op.
Yes.
When the jury found your client not guilty of the OUI.
I think that the negligent operation, and if you look at Zagwin, a Supreme Court case, a Supreme Judicial Court case that says operation, intoxication doesn't totally substantiate a negligent operation charge, but it is part of the evaluation. And aside from that statement, all you really have here is evidence of an accident. A defendant changed lanes, somebody turned in from a gas station, and there was an accident. And I would say some of the other stuff that came in, like the car seat being broken in half and the car being totaled and all these things that were not in any reports that were provided to the defense ahead of time, all went to the negligent operation charge. So I think the violation is significant and greatly prejudiced the defendant in this case.
Is there any basis to believe that the prosecutor knew that Trooper Murphy was going to testify about the defendant's admission? Because that wasn't the question that was asked, right?
No, and I think no, and I think he asked for what's coming in, and then when Trooper Murphy gets there and he's telling the judge, I have no idea what he's going to testify to. He says, "Can I just voir dire him?" The judge says, "No, I won't even let you voir dire him ahead of trial, but I'll ask the Commonwealth. Commonwealth, what is he going to testify?" And the prosecutor says, "Just what's in the reports, no surprises." And then you have statements against interest that go directly to the heart of the charges. So
you agree, no prosecutorial misconduct here?
No, I don't agree with that. I'm sorry. I don't believe that a prosecutor who did any, I'm sorry, I might have misunderstood your question.
Is there a basis to believe that the prosecutor knew? So
that's why I say mistrial with prejudice. I think the prosecutor knew or should have known. If you are prosecuting an OUI case and you don't know that your key witness who's going to testify for the whole first day of the trial is going to say that the defendant admitted to him that he ingested alcohol, I would say, yeah, definitely misconduct.
Should have known at least.
Should have known at least.
So he was found not guilty on the OUI. What type of an accident was this?
This was an accident where the testimony at trial was that Mr. Salvant he had taken his uncle grocery shopping. It was busy time of day, rush hour. He was coming to a traffic light. Somebody in front of him started to stop quite short. He moved over. Mr. Belgrade was either turning in or had just turned into the other lane, and he rear-ended him.
Rear-end accident.
Yes. And I think that, accidents happen all the time during rush hour, but for the Rule 14 violation evidence, there was not enough sufficiency for negligent operation.
I think we got it. Thank you very much.
Thank you very much.
We'll now hear from the Commonwealth. Attorney Morse.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth. First, I'd like to recognize ADA Kyle Signolfi, who authored the brief in this case. So I'll start with the peremptory challenge and then move through the issues the same way my sister did. So starting with the Batson source challenge.
We agree that it's a protected class.
So initially, the defense attorney did not make an adequate showing of a protected class, and it wasn't till after lunch that there was maybe a showing of that. Simply calling a juror a minority is not sufficient.
Isn't skin color a protected category under Batson?
Skin color is absolutely a protected category.
And can we assume that defense counsel identified this juror as a minority based on her skin color and didn't want to presume the identity, her particular racial identity, not knowing? Is that possible to presume?
So on the appellate record, I don't think that that's necessarily something you can assume at the time. I mean, obviously this is kind of a fiction because the trial judge was there and could see the juror, but under Batson source, the defense attorney has to make an initial showing that there's some sort of pattern of misconduct, and even though that can be a pattern of one, part of that record is to establish what the group is that the defense attorney is challenging the prosecutor for striking jurors about. And here, that showing was not made by the defense attorney when he initially made an attempt at a Batson source challenge, and so the judge appropriately denied the challenge at that point. After the challenge was revisited after lunch, we can kind of guess, based on what the defense attorney said, what the intended protected class was and what the juror's ethnicity was, because the defense attorney referred to, at that point, for the first time, referred to the jurors having the same background as his client, and then separately referred to the fact that another African-American juror had been seated. And so from those two statements, it's possible to infer that that was the protected class the defense attorney was getting at.
Do you deny that there was a Batson challenge articulated at the time? I guess my question goes to what other basis can a defendant object to the Commonwealth's exercise of a peremptory other than Batson source?
So the Commonwealth acknowledges that there was an attempt at a Batson source challenge at the time.
Okay.
And just
Okay, I appreciate that.
And it was inadequate. Even if it had been adequate, though, here, not only contemporaneously as part of the four-cause challenge, and also later after the defense attorney, after lunch when the defense attorney made a second attempt at the Batson source challenge, the prosecutor identified a genuine and adequate race-neutral reason that was completely separate from the juror's group identity.
Before we get to that, the Cosable case from 2021 says that a judge must find that both the genuineness and adequacy of the explanation are satisfied before allowing a peremptory challenge, right? So I think the argument here is the peremptory challenge was allowed, additional jurors were sat, there was a break, and then it got revisited, and that's kind of improper. What's your response to that?
So 2 points on that, Your Honor. So first, where the initial challenge wasn't sufficient, this doesn't matter anyways. And then second, the judge had actually already heard all the reasons why. And then even if that wasn't sufficient, the judge clearly already knew what the peremptory challenge was about, and even though the judge didn't use the magic words adequate and genuine till after the break, in Commonwealth versus Jackson, or sorry, not Commonwealth versus Jackson, Commonwealth versus Rodriguez, there was late consideration, and the Supreme Judicial Court did not consider that to be an issue. So I think here, I mean, where the court did find that the reason was adequate and genuine, any delay isn't a problem.
Are we to take anything from the judge's inquiry of the Commonwealth? I mean, I think it's the judge who raises for the first time, would you like to exercise a peremptory? Are we to take anything from that?
Absolutely, Your Honor. What that's showing is that the judge at that point believes that there's a reason the Commonwealth might want to exercise a peremptory challenge that's proper. I mean, the judge and the
Is that the judge's responsibility to sort of prompt peremptories, or just?
It's certainly not the judge's responsibility. It's just telling that the judge also believed that the prosecutor could, believe that the juror wasn't going to be biased. I mean, because the judge making that for-cause determination is the judge making their own determination. It's completely separate what the prosecutor might think about that juror and their ability to be impartial. And so the judge appropriately recognized at that point, and that's totally okay, although certainly not required, to your point, Justice Toone, recognized that the prosecutor thinks that the juror isn't going to be fair and impartial. And that was a reason the prosecutor wanted to preempt the juror.
And does it matter if the juror remained in the courtroom or had left the courthouse?
So, Your Honor, I think that would matter if the Batson source challenge was correct and the court needed to reseat that juror, but unless that's the case, I don't think it matters at all. Batson source is about what the prosecutor was thinking at the time that the prosecutor made the challenge, not whether or not there's a good reason to excuse the juror that like through further explanation or exploration.
Well, it's a little bit of a fait accompli, if that's how you say it. If the juror is like outside, has left the courthouse, right, and then you do the Batson source challenge, the only remedy is to put the juror on the jury, to deny the peremptory and seat the juror. And if she's down the road now, there really isn't a possibility of doing that. It just goes to when is, I think that the defendant's argument is sort of, you got to have this analysis of the genuineness of the race-neutral reason done at a time where you can actually apply a remedy if it's found not to be race-neutral. And that wasn't the case here.
So the difficulty of applying a remedy only matters if a remedy is warranted, and a remedy was not warranted here. I mean, this would certainly, it could be a different case if it weren't for the fact that the judge knew before the prosecutor even exercised the peremptory that there was a good reason to exercise a peremptory. So even here, there's like every suggestion.
Is there case law on that like a judge can just assume what the genuine race-neutral reason is without actually asking the prosecutor to state the reason? And that's not my understanding of how Batson works. Batson requires an inquiry into the prosecutor. Why are you striking this juror? And then they have to provide a reason to the court. And so just to say, well, I know what you're going to do, go ahead, doesn't seem quite the process that Batson source contemplates.
So that's certainly not the process that Batson source contemplates, and the proper process was actually gone through here. My point there is just simply that the defense's concern is if a remedy wasn't available, how was a judge going to grant a remedy? Here, it's pretty clear the judge didn't think a remedy was warranted from the beginning based on what the judge had already heard. And so the fact that a remedy wasn't available is...
There would be a remedy, wouldn't there be? Let's say Batson source plays out and the judge says, that's not genuine, that's not adequate. Judge declares a mistrial.
Right.
Here's your remedy.
Yes.
Start all over again.
Yes. And so it's a different remedy than reseating the juror, but certainly the case wouldn't go forward if there was an appropriate Batson source challenge.
Do we know where the juror was?
We don't know, Your Honor. The juror was certainly dismissed from that courtroom, and then there was a lunch break, and we can speculate as to whether or not the juror was being held for a second trial, but probably not.
Can we turn to the issue of the mistrial and the violation by failing to disclose the statements?
Yes, Your Honor. So the Commonwealth acknowledges that the failure to disclose the trooper's statements about what the defendant said was a Rule 14 violation. That was the Rule 14 violation, not any of the other evidence claimed by the defendant. There is no evidence here that the prosecutor knew about that statement. That statement was...
How did the prosecutor not know? This is a question I asked defense counsel, but how did the prosecutor not know that the trooper was going to say the most damning thing that a trooper can say is that the defendant admitted that to me, this fact.
So, Your Honor, first let me push back a little bit on that. There was a lot of other evidence of intoxication, and this was kind of just one minor statement about possibly he had something to drink earlier that I think is far outweighed by the other evidence of intoxication. But to answer your question, this was a district court trial. It wasn't in the police report. It's not uncommon for prosecutors to meet with troopers for the first time the morning of the trial. And it's not, so this is just kind of in the routine works of district court for this to happen. The prosecutor's question did not call for this answer. He was asking about what the trooper had observed about the defendant, and so there's no indication that the prosecutor had any knowledge of this, and that's a very reasonable thing in district court.
So the remedy that the judge selected of all of the remedies potentially out there for a violation of Rule 14, you say was adequate. Tell us why.
It certainly was. So first, the judge struck the answer from the record, and then second, although initially—
Did the judge do that? Because it was strike the last answer, but that actually wasn't the last answer. It was a couple answers prior.
So the judge says to strike that last answer about what the defendant said, and this was the last answer about what the defendant said. I think that striking it more specifically would just call more attention to it, and that's not really something the defense wants either. So this was an appropriate way to strike that answer, and I think that the only way that that can be understood is to strike the testimony about what the defendant said.
So defense counsel says judge should have prohibited the trooper from testifying. The judge should have given a Bowden instruction. The judge should have given some sort of curative instruction. Tell us why striking in the language you appropriately quoted of what the defendant last said and his general jury instructions was sufficient in this case.
So, Your Honor, I think it would have been sufficient if the judge had just struck the answer, as he did, and gave the jury instruction about struck answers are not part of the record, which he did. In addition to that, the judge also did let the defense attorney, even though he initially indicated he wasn't going to, he did let the defense attorney cross the trooper about not writing a report, not including stuff in a report, calling into the question the trooper's credibility, and he did that quite effectively on cross. The instructions that the defense counsel asked—
Can I just say, is that really giving him anything? Of course he's entitled to do that. It isn't right. Yeah, 13 years.
Yeah, cross-examination doesn't seem much of a remedy.
13 years I heard these cases, so not much.
Your Honor, of course the defense attorney is entitled to cross-examination. The point here is just that cross-examination effectively cures any prejudice caused by the trooper's statement coming in. And that's really the point more than whether or not this is wide latitude. The instructions that the defense counsel requested are not really appropriate. So first off, the instruction about humane practice is actually something that would have been really problematic in this trial because it suggests that the defendant is so intoxicated that he can't make a statement to the trooper that's voluntary. And that's not actually appropriate in an OUI trial because it's actually highly prejudicial itself, I think. The Bowden instruction is also not really appropriate because it talks about whether or not they did this or that to investigate as opposed to being really specific to this. And so I don't think that would be particularly helpful either. In addition to this, the evidence that was admitted at trial of intoxication was pretty substantial apart from this one offhand comment. There was evidence about the defendant's poor performance on 3 field sobriety tests, that he smelled of alcohol, had glassy eyes, slurred speech, and all of that evidence is significantly stronger than just whether or not the defendant had anything to drink that day.
And so that evidence wasn't sufficient to convict him for OUI. So what's the sufficiency of the evidence? I believe your sister makes an argument with respect to the sufficiency of the evidence with respect to the operating to endanger.
Yes, Your Honor. So first, let me push back on whether it was sufficient to convict him of the OUI. The jury did not convict him of the OUI. They certainly could have on that evidence, and they chose not to, and that's what they can do. So the evidence of negligent operation here was the circumstances of the crash. The victim of the crash testified that he had been at a stoplight for 3 to 5 seconds when the defendant's vehicle hit him from behind, and the severity of the damage in that crash suggesting that the defendant was going at a high rate of speed. Airbags were deployed, a car seat was broken in the other car, the victim's car was totaled, and there was substantial damage to the defendant's car. And then that alone is sufficient, but in addition to that, there was evidence that the defendant was intoxicated. And this court can consider that regardless of the OUI outcome.
I think we got it. The matter stands submitted. Thank you both.
Thank you, Your Honors.
You want to take a break? Keep going. Take a break. Keep going. Keep going. The next matter on our list is 23P 1450. Joseph Cogliano versus Stephen Hornsby, and a member of the Town of Norton Planning Board. I believe you're Attorney Needham, is that correct?
Yes, good morning, Your Honor. Excuse me while I clear my throat.
Sure.
This case concerns a solar energy project in Norton, Massachusetts. It's an extremely large solar project. The lithium-ion batteries for storage are 296,000 pounds of lithium-ion batteries in an aquifer, in an area of extreme sensitivity. It's called an AC, an area of concern, environmental concern. And because of that, in an ACEC, you're required to have the highest standards of environmental review and protection. And it was not mentioned in the decision that we're appealing here today, the decision in the land court. But the decision in the land court basically gave the developer Nexon the green light to go forward. And our overwhelming and overriding concern here is the location. It's located in the area of critical environmental concern. It's located in the Canoe River aquifer. It's in the floodplain. It's in the floodway. We don't think it's anywhere near close to being an appropriate spot to site.
Did the board grant the permit to Nexon?
Well, that's complicated. They were ordered to. They denied the permit. And they initially denied the permit. And when they initially denied the permit,
Was that the first time it was sent back, or are we talking about kind of in second part?
They initially denied the permit. And when they denied it, they said, members of the board expressed concern over batteries being located within the floodplain district and the fact that an installation of this type and size had never been built in Massachusetts, particularly in a protected overlay area. So that's why they did it. Nexon appealed that. And when we got in front of the judge in the land court said, we're going to have summary judgment here, but we're not going to have summary judgment on the batteries. And there was no summary judgment on the batteries. It was excluded from the batteries. And then he entered judgment on the final judgment, and after that, and he entered final judgment and sent it back down to the planning board with instructions to issue the permit before the court had even dealt with the issue of the batteries. Very significant issue. He sent it back and said, he sent that back down, and he said to them, I'm looking at it right here, that the board shall issue the floodplain overlay district special permit in compliance with section 175-13.4C of the bylaws of the town. And that's part of our objection. So we do not think that we have the burden here, because we think we're right back where we started.
You're not right back where you started. The battery issue may be something that we can talk about now, but the initial decision by the land court judge to annul the board's decision and send it back, that you've already appealed that. You appealed that decision. And the rule is that any issue that's on the face of the judgment that you're appealing from needs to be raised in that appeal. So I guess the question is, maybe the battery issue now is before us, but really, and the validity of the floodplain permit that was issued might be before us as well, but not the judge's decision initially to direct the board to issue a permit.
Well, the problem here, Your Honor, is that this permeates absolutely everything with the batteries, because you have a floodway, and you can't, even based on the 13.4, which is what was upheld. The 13.4 talks about the floodway, and we've already established that there is heightened standards. And with regards to the floodway, they have to do a detailed study. They didn't do a detailed study. 13.4 says you can't build in the floodway, you can't raise the floodway above zero increase. And that can only be determined if you know where the floodway is. They didn't do a detailed study. They're obligated by the law to do a detailed study.
But those are issues you could have raised in your first appeal.
Well,
right? You could have raised everything but the battery issue in your first appeal. Your argument in this brief, you say the land court erred in applying the Dover Amendment to Nexsun's proposed lithium-ion energy storage system. That's an issue you could have raised in your first appeal. You also argued that even if the Dover Amendment applies, the planning board acted within its authority. That's an issue you could have raised in your first appeal. So we just have to look at the issues that you can only raise in this appeal. And that seems to be limited to maybe the issue of whether the batteries are an integral part of the project, and maybe some other issues. But do you understand sort of the problem here, that you don't get a second bite of the apple if you have an opportunity to raise issues? And you were fully engaged in this litigation at the time the summary judgment order was issued. The judge allowed you to address all the arguments, and you took an appeal from that.
well, he sent, there had been no further findings. When he sent this back to the planning board, they didn't conduct any hearings or do anything, and I'm not sure I agree with Your Honor's position, because at the time, we could not appeal because we could do nothing about the floodway, we could do nothing about the batteries, and the batteries...
Could you have made your Dover Amendment argument on the first appeal?
We made that. I believe we made the Dover argument.
So you certainly can't make it now, then. If you made it the first time, you can't make it the second time.
Well, this is the first time.
First appeal. The first
I
appeal.
think what I'm trying to get across to you, the batteries permeate everything. 296,000 pounds of lithium-ion batteries in the aquifer, in the area of critical environmental concern. That just permeates everything. And so the idea that we're here and all we've got is the batteries are everything, and they leach into everything else that's in this case. They leach into the area of why you need a detailed floodway plan, which they didn't have. They didn't even know where the floodway was. And under cross-examination, they said, if we did a detailed mapping, we could know where the floodway was. We didn't.
Let me try this one more time. You argue the land court judge based its decision to override the board on the so-called Dover Amendment. I'm not sure if that's true, but that's a point that you certainly could have made in your first appeal. Isn't that correct? It doesn't have anything to do with batteries. That's an argument about the application of the Dover Amendment.
Well, the reason I'm hesitating, I'm not being evasive, but I think the error that was made in excluding the batteries, and we'll get the big 2,000-pound elephant in the room of the batteries. So we'll not do anything with the batteries. We'll try to get rid of this case. I don't think you can get rid of this case without including the batteries and everything that flows from the batteries, because the overwhelming thrust of what we're raising here is you can't put this in an aquifer. It seems preposterous to take all the places you could put lithium-ion batteries in this massive amount. you elect to put them in a very sensitive environmental area. So the batteries permeated everything. The batteries are the reason that this was improperly decided.
I'm going to ask you a question just in a slightly different way. Is it your position today that you can argue everything that you argued in the first appeal again today? Yes or no?
Not everything.
Okay, so what can't you argue?
I think we argued that the notice was incorrect when they first did this. We noticed that the composition of the planning board was inappropriate because they got a new member and they didn't get him up to speed. And I think that was pretty much the thrust of what we argued.
Yeah, but the test isn't the arguments you made in the first appeal. The test is the arguments you could have made in the first appeal. And whatever is on the face of the judgment is what you had an obligation to raise in your appeal. You can't come back for a second bite of the apple and raise issues that could have been raised in the first appeal. So the question is, what couldn't you have raised that you're arguing now in the first appeal?
I don't have the opinion in front of me, but my memory is, in the opinion, the appeals court said, you'll have a chance to come back. You'll have a chance to come back because we raised the issue.
It says, once the validity of the floodplain special permit is finally resolved in the abutter remand litigation, the abutters can pursue their arguments with respect to the floodplain special permit before this court. That doesn't mean that you can challenge the land court's decision to direct the board to issue a floodplain special permit.
Well,
so I guess with your time, I would encourage you to focus on the arguments you have with respect to the validity of the floodplain special permit that was actually issued.
all right.
And you don't get the benefit of a de novo type review. There is going to be deference applied to the judgment of the board here.
All right, to issue the special permit, there has to be compliance with 13.4. And the 13.4 is not only that there be no increase in the level, but there be no increase in the level at any point. And that's why you have to do a detailed study. They don't know where the floodway is. Admit and understand they don't know where the floodway is. And admit and understand that if they did a detailed study, they would know where it was. And they'd have to do one because the flood elevation certificate requires that it be not more than 0 at any point. And the floodplain certificate they submitted doesn't say that. They just said that it didn't exceed. And the floodway, because there's been some misunderstanding. The floodway is basically the area that's left, so when you have the 100-year flood, once every 100 years, when the base flood overfloods, it will have some place to go without raising the water level. And it says in the bylaw, floodway, the channel of a river or other water course and the adjacent land areas that must be reserved in order to discharge the base flood without cumulatively increasing the water surface elevation more than a designated height. That designated height is 0. You can have no increase whatsoever. So it's impossible that you could have a permit and approve a permit that says there'll be no building in the floodway and there'll be no increase in the level. And they ordered the planning board to issue the special permit. So they ordered them to issue a special permit when nobody knew where the floodway was, and everybody knew how to find it out, and nobody bothered to find it out. And I think that's what happened. It was sent down to the planning board. They didn't hold hearings, and they were told that they shall issue a floodplain overlay district special permit in compliance with 13.4. So that's what they did. They issued the permit without having done any determination as to where the floodway was. And this is an important area. And they, in addition to that, they, and I'll get to some of these other points as quickly as I can. And you're going to see on, I think it's Exhibit 57.3, is that there's gray in a diagram which shows you there's something called bordering land subject to flooding. And bordering land subject to flooding basically means that the floodway extends over this whole area, that these batteries are in the floodway, and that determination by the planning board, we think, is faulty for that reason and other reasons. In addition, with this system, you've had a couple of things. You're talking about, they've also been digging in the floodplain, because we've shown you in diagrams that we've attached that right in the floodway itself, and the floodway starts at the middle of the channel, and the question is, how far out does it extend? And it has to extend out far enough so when the 100-year flood comes along, the water level won't go up. And so this bordering land subject to flooding is virtually the whole area. When you look at that diagram, you're going to see everything in gray. Everything that's in gray is a bordering land subject to flooding, and that includes just about everything. So a couple of quick points. They did not have a, excuse me for a moment. They mentioned in their brief that the certificate of superseding conditions and MEPA found everything to be in order with this, and that just is no determinations about the thermal runway. And that's the problem when there's a thermal runway. The judge made specific findings that in a thermal runway, there, to a reasonable scientific certainty, there would be contamination of Mr. Cogliano's wells. So it is a very serious, significant problem, and that this MEPA that gets mentioned does not involve itself in any of that. It's just kind of a bureaucratic permission to go forward. And the size of this battery is basically, it is not an accessory of any kind. It's not mentioned, the batteries aren't mentioned in the bylaws. And this ESS is something that's brand new, that hasn't been around for any period of time.
What's the purpose of the battery?
It's storage. It doesn't generate any electricity.
And it's storage for what purpose?
To sell it to the grid, basically to generate more income. And everybody has said...
Well, hold on, I'm not sure I follow that. So,
okay.
So the energy gets stored in these batteries, right? And then when does it get called on?
Well, what happens is if you don't have batteries, you can only sell so much electricity. But what you can do with this is you can keep saving electricity, and then you can be sending it to the grid. So you can make dramatically, the storage enables you, and it's very new under the sun. 2018, 2019 is when it happens with the SMART program. It enables you to store, it enables you to, there's something called an adder. It enables you to make much more money. And it has nothing to do, they're standalone, a lot of these energy storage systems are completely standalone. They don't generate any electricity. They store it to sell it to the grid.
And is there a value in storing that energy to the community?
Well, there's a value to the people that generate it because they sell more and they make more money.
I get it, but is there a value to the community?
Well, there may be some monetary value, but we think that the risk of a catastrophe is so great to a critical place where the drinking water for Mr. Cogliano and for the town of Norton as well is involved. And if there is one of these thermal runways, you can't put them out. You have to let them burn out, and they can go on for days and days.
And so you say you think the risk is so great. Has an expert came in and told you how great that risk is? Is it one or two out of 100, or what is the risk?
Well, it's at least 1 or 2% in a given year. And the expert that they had, because they have said that they have a hazard mitigation plan, and when their expert was testifying, he said, well, that's above my pay grade. And we had an expert who testified that you can mitigate the risk, but you cannot eliminate the risk. And the risk says is 1 to 2%. But the most important part about that is if there's a risk, there's a fire, there's a catastrophe, there's a fouling of water, and so it seems to make all the sense in the world. If you're going to put this ticking time bomb any place, it should not be in an ACEC, because that's what the thrust of this is, because the holocaust that will follow, and the judge found that. I mean, he ruled against us, and the judge seemed to think or he found that if you take enough precautions and enough steps, it gets the risk into kind of a palatable area. But under the circumstances, if there is one of these runways, and they have them all the time, you'd read in the newspapers all the time, iBikes and everything else with these lithium-ion batteries. This is a huge, powerful, ticking time bomb, and the result is an environmental holocaust.
Thank you, Counsel. I think we're going to have to leave it there. I see that's your time.
Thank you.
Annie Moran Carter. Were they able to quantify the risk of a fire? Is there a number for that?
I'm sorry, Your Honor, may I
Is there a
say?
number for what the risk of a fire, or the likelihood of a fire is in a project like this?
There was testimony, Your Honor, by the plaintiff about a report that was generated several years before the time of trial, about a 1% to 2% risk on an annual basis in that studied year. The plaintiffs have erroneously extrapolated that to a 70% chance of likelihood over the lifetime of this project. And that's, of course, not how probability works, Your Honor, and certainly not what we think the risk is. On cross-examination, the plaintiff's expert who testified about this particular report also acknowledged it was on a basis of kilowatt hours. So there could have been one project, one very large project, that would have accounted for the data that developed that risk.
But you agree there's an annual risk, 1% to 2% of a fire, even with all the safeguards in place? That's what the testimony established? That
was the testimony, Your Honor, yes. But let me, I can organize my thoughts in a multitude of ways, Your Honor.
We'll start with, what's the issue before us?
Certainly. Your Honor, this is an appeal of a land court judgment that upheld two decisions. One was a decision upholding the grant of a site plan approval for Nexsun's 2 milliwatt project, solar project that's being built in Norton. The other was a land court judgment upholding the grant of a floodplain special permit for that same project. So as Justice Toone identified, this is not an appeal of the land court's decision that was resolved 3 years ago on summary judgment and upheld by this court about whether or not the land court erred in directing the board to issue that floodplain.
Can you just, what is your position with respect to when the judge said in this summary judgment decision, there's a factual dispute regarding the nature of the batteries to be used and the regulatory regime with respect to those batteries? So is that issue before us insofar as it implicates the judge's initial decision to direct the board to issue a floodplain permit? Or I'm trying to understand how does the battery issue still live under your understanding of what's precluded and what's live?
My understanding, Your Honor, is that the question on summary judgment that Nexsun had teed up and that the plaintiffs opposed in their summary judgment pleadings participated in argument on it is whether or not the batteries are separately regulated, either as an accessory use or as part of the project. It was their as-of-right status, because of course that dictates what sort of discretion, if any, can be applied to a review of the floodplain special permit. And let me explain that, Your Honor. The bylaw that we are operating under is now annulled in Norton, but the operative version of the bylaw created as-of-right permitting for large-scale ground-mounted solar photovoltaic installations like this project in certain zoning districts in which this project is located. And the law says that as-of-right uses cannot then be subject to discretionary review. Now, the land court reconciled the floodplain overlay district special permit with the as-of-right nature. Nexsun had argued and did not prevail in this argument on summary judgment, saying, Your Honor, we're as of right, no floodplain special permit. And the judge said, not so fast, the floodplain overlay district can be reconciled because, and this is very important to remember as well, Your Honor, the floodplain overlay district is not about environmental regulation. It's not about analyzing a project's environmental impact. The project went through extensive environmental review before the Norton Conservation Commission, before the Massachusetts Department of Environmental Protection, and through the MEPA review, which is not just an administrative review. It's the most exacting environmental review that the Commonwealth has. And it obtained a superseding order of conditions confirming the compliance with the Water Protection Act, the Wetlands Protection Act and its enabling regulations, and MEPA certification. Floodplain special permit is all about making sure that there's not reducing the risk of flooding and the cost and damage associated with that. That's the limited purview of Article 13. And special permits granted under Article 13 have two objective standards: whether or not the project will add, fill, excavate, or build structures within a floodway, and then whether the use, in combination with other existing uses, will increase the risk of flooding in the event of a 100-year storm, the base flood elevation. Those are the two objective standards. No discretionary standards such as whether or not there's an alternative location, whether or not this is a socially or economically viable project. Those are discretionary standards applied under Article 10 of the bylaw, which relates to general special permits, which the board had originally applied when it denied the floodplain special permit. So again, the concerns about the environment, those were addressed in a separate environmental regulatory process that is not the subject of this appeal.
The issue, oh, sorry, go ahead.
I'm sorry, you're on.
The issue with respect to the batteries then is, how would you formulate that issue?
Yes.
What's before us now as to the batteries?
Thank you, Your Honor, that was your original question. So the question on summary judgment that the court did not reach and said we're leaving this for trial is whether or not those batteries are regulated as part of that as of right use, which the parties all acknowledged under the operative version of the bylaw. The solar generating system was an as of right use. Are the batteries part of that as of right use and therefore can't be subject to discretionary review under the floodplain special permit, or are they separate? And so that was the question at trial, Your Honor. The decision that the land court reached in deciding what is part of a solar generating system, that's the term that's used in the bylaw, right? And the court looked for guidance in the Tracer Lane decision, Your Honor, which was the SJC decision decided 2 years ago. And in that case, it was a question of an access road that led to the solar project itself. Solar project was located in Lexington.
And in that case, they said the access road was indeed part of the project,
Right.
correct?
And the reason, Your Honor, is the SJC engaged in understanding the importance of that road to facilitating the collection of solar energy. That road was only used for the initial construction of the project and periodic maintenance thereafter. So it's...
Well, just to pause for 1 second. So let's assume for the sake of discussion that it is part of the project. Does that mean that it's not subject to the excavation and the fill requirements?
No, Your Honor. Those are objective standards. The project as a whole is now, so the court made a finding of fact and a ruling of law that the project was an ancillary part, an integrated part of the solar system. That solar system is as of right. It is therefore subject to both the site plan review and the floodplain special permit. And the land court made factual findings and rulings of law on both. I can turn to the floodplain permit and the two objective standards, which is also part of the plaintiff's analysis. So the court made detailed findings on both of those two standards. So again, two standards under Article 13. Is there fill, excavation, or a structure in the floodway? And separately, this subsidiary finding, which I don't believe is a part of the plaintiff's focus in their appeal, but whether or not the uses in combination with one another will increase the likelihood of flooding in the event of a 100-year storm.
So these containers, there's 4 of them, right?
There are 4 of them, Your Honor.
Huge containers.
They're shipping containers, yes, Your Honor.
And are they on stilts?
They're elevated on a skid, Your Honor, so it's like a metal platform on which they're elevated. They're outside of the floodplain district, Your Honor. And I think that the best way to illustrate this, and I believe you may be able to call this up, Your Honor, but it's at Chalk D, which is at Record Appendix 3, Volume 3, page 211. And I think that'd be helpful to illustrate as we walk through this analysis. So the floodplain district as an overlay district is a function of the bylaw. It's defined by the language of Article 13. And Article 13 says floodplain districts are coterminous with special risk areas, special flood risk areas as defined under FEMA. And they have these designations, Zones A and Zone AE. And if you look on Shakti, Your Honors, the floodplain district is shown in the magenta dashed line. So that's the floodplain district, right? The floodway, which is prong 1 of the special permit analysis, is a much narrower area. And the bylaw, again, informs our instruction and the court's analysis, right? So the floodway is defined as the channel of a river or other water course and the adjacent areas that shall be reserved in order to discharge the base flood without cumulatively increasing the water surface elevation. So we've got to find a channel of a river, and then those areas that have to be kept clear so that if there is a 100-year flood, there won't be an increased risk of flooding. And the bylaw further instructs in Zones A and Zones AE, that's where we are, in Zones A and AE, along water courses that have not had a regulatory floodway designated, the best available federal, state, local, or other floodway data shall be used to prohibit encroachments in the floodway, which would result in any increase in flood levels within the community during the occurrence of the base flood discharge. So nothing in there says that project proponents need to perform what's known as FEMA detailed studies. There's no obligation in the bylaw to do so. So what findings of fact did the court make to support the first identification of where the floodway was? Well, the land court took a view on day 1 of the trial, Your Honors, and made several facts that informed his determination of where the floodway is.
Is the floodway in this chart that you pointed us to?
It is, Your Honor.
Is that the blue line?
It's the Green Brook area, which is Mulberry Meadow Brook. That runs along a north-south axis, Your Honors. That's the channel of the water course that we're talking about. Significantly, as it relates to structures, you can see that the majority of the project components are to the east. They're outside of the floodplain district. They're not even close to the floodway, let alone, they're not even within the floodplain district, let alone the floodway. So there's this channel of the Mulberry Meadow Brook, but one important feature is the topography. The brook is set below, it's at a lower elevation, and on either side of the brook are cranberry bogs, and then above those are an elevated dike roads or berms, what the court called are berms. This is a cranberry farm, and so there are roads that allow farm vehicles and people to cross over the brook that is elevated above the brook. The brook runs underneath it. And so the court identified the Mulberry Meadow Brook as the floodway and the area immediately adjacent. Now, the plaintiffs would argue that all areas adjacent to it are part of the floodway. But of course, we have to go back to the language of the bylaw, right? The bylaw says the channel of the water course and the areas adjacent to that water course that have to be kept clear in order to avoid an increase in the water elevations. So there's a flood coming through that water course. We need to keep some areas so that it doesn't increase the risk of flooding. And of course, the lower elevation nature of the topography of this land, again, specifically identified as part of the court's findings, was important in terms of the land court making a finding of where the floodway is and what needs to be kept clear, right? More importantly, he also made findings on the 3 things that need to stay out. There was testimony from Stacy Minahan, which is the Nexsun's consulting engineer, that there's no fill, no excavation, and as we showed, no structures within the floodway, right? There's been some suggestion in the plaintiff's papers about a specific cross-section detail. You can find that, Your Honors, at Volume 1, page 378M. This is a cross-section detail, again, at the permitting stage, not at the construction stage of documents, that shows how underground conduit will be built and placed on the project. They will do a cut and cover method, which is cutting the trench and then using the material that was cut out to cover the conduit. There's a singular location that the plaintiffs have fixated on in their argument, which is shown at Record Appendix 378I. And this is along one of the dike roads that we just talked about.
Record Appendix 1, 378?
Yes, I'm sorry, Your Honor. Oh, yes, Record Appendix 1, 378-1. There's a dike road that crosses at the southern portion of the project where there will be underground electrical conduit that's exactly this, a trench is cut within the footprint of the existing dike road and then covered. There's no change in the surface elevation, and more importantly, the dike road is elevated above the water course of the Millbury Meadowbrook. There's no digging in the middle of the creek, as the plaintiffs have suggested. There's no evidence to support that. Your Honors, I'm out of time. I will rest on my papers on our cross appeal on standing and trial exhibit 55, unless the panel has additional questions for me.
Seeing none, the matter stands submitted. Interesting case. Thank you both.
Thank you, Your Honors.
We're close to our last one. The final matter for the day is 24P0012. ROCHA and another versus Medina and another. Attorney Rossetti.
Thank you. Members of the panel, may it please the court, my name is Michael Rossett, and with me today is Kimberly Iverson Tufo on behalf of the defendant appellant NILTON MEDINA, MD. As outlined in our brief, I have 4 to 5 major arguments, each of which I think is important enough to merit discussion today in detail. Each of the grounds of our appeal is sufficient to send this case back down for a new trial. I just want to briefly review them and then get into the first one. The denial of the motion for a new trial was reversible error based on the HUG instruction and the failure to give an instruction to disregard that testimony. A mistrial was repeatedly asked for in a timely manner. There was a timely, it could have been earlier, but a timely enough request several times for a curative instruction for the judge to inform the jury to deny or to disregard that testimony. Instead, what happened was the judge allowed the jury to decide whether or not that was relevant. And I'll get to the reasons why I think that was particularly problematic, because a lot of these are intertwined.
Well, let's not go through a list of the issues. We know what the issues are. Since you raised it up, you agree there wasn't an immediate contemporaneous objection to this?
There was not an immediate at the time, but there was one that was timely enough under the law, made later on while the plaintiff was still on the stand. And not only that, but even before the time of the jury instruction, before this went to the jury, and the judge instructed the jury, there was repeated timely request to inform the jury to deny, to
the testimony was given on direct examination, then there was examination by the husband's counsel, then there was cross-examination by you, the defendant, then a morning break, then a keeper of the records testified, then the plaintiff's testimony continued, then a lunch break, then you asked for a mistrial. Is that the correct sequence of events?
Yes, yes.
There's no objection to the evidence, no motion to strike. You just went right to you asked for a mistrial based on that.
Not at the immediate time. There was an objection to the very first question that was asked, but then a follow-up question was asked. And true, there was not an objection made at that time, but under the law, it was timely
The objection the first time Do we know what that objection really went to? Did that go to the form of the question?
It's not clear on the record.
It seems that they asked the same question in a different form, and there was no objection.
True.
So it seems clear on the record that it was to the form of the question.
True. But more importantly, later on, as it became clear and there was time to process, there was no, for instance, no tactical reason not to object at the time. It was, as the judge said and recognized, pretty shocking testimony. It came out of the blue, and I can address that issue later. But a timely objection was made, and a timely request for an instruction to disregard that was made repeatedly and before it went to the jury.
So the judge said, I'm not going to disregard it, but I'll tell the jurors, hey, it's in, use it for what it's worth, but if anything.
Yeah. But it was clear under the law, and even in the judge's mind, until we get to the credibility issue, which I'll address, that it was not relevant to any issue. For instance, it was not relevant to standard of care or informed consent. It was not even listed in the joint pretrial memo as an unusual issue. It was not included in the plaintiff's expert disclosure as a basis, a factual basis for an opinion. It wasn't relevant to that. The judge recognized that at sidebar when the first two issues that the plaintiff's counsel raised at sidebar for justification for this shocking testimony that painted Dr. Medina as a creep.
That was a creep. We get it. I understand. Let me ask you this question, though, and I'm going to let you finish that thought.
Thank you.
Did it come up during the doctor's deposition?
He was asked at his deposition whether he did that, and he denied that.
Okay.
All right.
So does that constitute notice?
Not adequate notice for that in light of all of the rest. There was no evidence in the discovery, and particularly in the plaintiff's deposition or her answers to interrogatories, no supplementation of those interrogatories.
Was she asked those questions in her deposition or her interrogatories?
She was asked, as it was stated on the record by trial counsel, she was asked to describe everything about the interaction, what was said and what was done, and that never came up. That should have been subject to a disclosure, either through a supplemental answer to interrogatory or at least flag it in the joint pretrial memorandum.
Did you depose the plaintiff after the plaintiffs deposed your client?
No, she was deposed first, and then several months later, Dr. Medina. And this was years before. It's clear that this was a tactical decision to hide this information, which plaintiff's counsel said on the record only came to him sort of later on in the case. But at that moment, and from then until time of trial, he should have raised this to flag it.
Well, I mean, they asked Dr. Medina, do you remember hugging the plaintiff? And he said no. And he said no. And I guess that you have decent arguments as to the relevance, I understand, but just sort of that might put you on notice that this is something you should ask to find out what their story is about this, right?
Yeah, I mean, plaintiff's counsel asked him at the trial a different question, although he said, hey, do you remember that I asked you before whether she was completely naked, unclothed? Those aren't the exact words, but that was the effect. And that's meaningful in a case where this is a breast reduction surgery. You could understand in a post-operative visit why she would not have a top on, because they're examining that. But it was absolutely wrong when he asked him at trial, don't you remember when I asked you that she was without any clothes and you gave her a hug? And he said, no, I've never done that. That's absurd, and that's correct. That doesn't then flag this for being a responsibility for the defendant to then raise this with the judge.
Well, it makes you wonder why they asked that question, right?
Sure it does. You know, and I'm not denying that there could have been, but to say that that's the responsibility of the defendant, this was a tactic by the plaintiff's attorney to ambush with an incendiary.
Let me interrupt for a moment. If you're going to ambush, you do a better job than bringing it up at a deposition, asking outright the question, having them deny it. But even if I disagree with you on that point, how much of this case really was kind of influenced by the hug? In other words, there was a lot going on in this case that the jury could have considered, and an instance of perhaps Dr. Medina acting in a way that a jury could consider was reflective of his negligence and his knowledge of that and trying to make this go away. How important was that in the overall case? Because there seemed to be quite more that was focused on really just the standard of care and informed consent than this one portion of the trial that wasn't mentioned in openings, wasn't mentioned in closings, and it was one small bit.
It wasn't mentioned in closing because the judge said, don't mention it in closings. I'm going to address it by leaving it up to them. And how important was it? It was crucial. It infiltrated the whole trial. It was the subject, as you know from reading the transcripts, the subject of much sidebar and discussion out of the jury's presence. And we cannot know we can't say that it didn't influence the jury's decision.
One of the verdicts go your way?
Pardon?
Did one of the jury verdicts go your way?
They did, the informed consent, correct.
Was that supposed to be hinged to this hug?
It's really, that's the judge wrongly let the informed consent go to the jury and justified allowing the jury to decide whether or not this was relevant strictly to the informed consent. That's true, but that never should have gotten to the jury. The timely objection was made, and repeated objections to informed consent and a motion for directed verdict as well, there just wasn't sufficient evidence. I want to touch on that because I said earlier these are intertwined in the record. The causation was a big issue. Obviously, the but-for causation instruction was diluted with the improper language of was it a factor? Did it have an impact? Did it make a difference?
Wasn't the new Superior Court model jury instruction, didn't it kind of mirror the dual? I mean, you wanted the dual instruction, I think was what I read in your papers.
Right.
And if you look throughout the model jury instruction, it's footnote after footnote about how it kind of mirrors language and why it's not using some of the specific language but for in dual. Isn't it essentially the but-for standard?
No, it's not.
Why not?
Because it includes the language of made a difference, did it have an impact, and was it a factor? The very kind of diluting...
Oh, wait, in dual, the SJC says, the purpose of this but-for standard is to separate the conduct that had no impact on the harm from the conduct that caused the harm. And you're saying, well, you can't use the word impact, because that has nothing to do with but-for causation. That seems exactly what the SJC, in terms of formulating the but-for standard in kind of real person terms. I just don't get that part of your argument where you're saying impact, using impact was doing something other than but-for causation.
Well, even if you reject that argument, the two other, was a factor, which was the very last line of the jury instruction, and made a difference, are confusing. I know this issue is before this court in the McDonough case, and it was recently argued and loopholed before the SJC. It's confusing. Jurors are confused by that. In McDonough, I don't want to get off the record here, but a jury specifically said, we're confused. This seems to contradict the but-for when they use that language.
At the end of the day, what was the issue that the jurors were trying to determine? Were the issues that, one, did this high nipples result from a bottoming out, or was there negligence on part of Dr. Medina? Were those the two choices?
The only issue for the jury to decide on standard of care is whether or not the plaintiffs met their burden of proving that, he did something that he shouldn't have done or failed to do something that he should have done under the standard of care.
And the argument there is the measurements.
The measurements. That was the only argument, and we're not arguing that there wasn't sufficient evidence to go to the jury on whether the standard of care was met, but he said, the plaintiff's expert said, the failure to do those two measurements breached the standard of care. The first measurement, he had no problem with. He did not say that he did it wrong. He said it's the gold standard. But crucially, there was never any expert testimony, and expert testimony, as you know, is required in these cases, that tied in the failure to do the two measurements that he said should have been done with the alleged bad result. There's a lot of other evidence for explaining it, but we don't even have to get there. The plaintiff on the appellee on brief tries to make the argument that, hey, this was a simple case, you had to believe one or the other. No, that's not true. That puts the burden on the defendant to disprove something. We didn't have to, or trial counsel below didn't even have to put in any evidence. They could disbelieve our expert, but what they have to do is base their decision on credible expert testimony that supplies the causation link, and there was none. There was no causation, as we argue in the brief, testimony by Dr. Weinstein that the failure to do these measurements caused what he said was the bad result. Likewise, at the very end of his direct examination, plaintiff's counsel basically confirmed with him that there's no informed consent claim here. He said, what's the duty on informed consent? He said, to advise of the inherent risks. And he said, is bottoming out or a high nipple an inherent risk of this surgery? And he said, no. So it's not surprising, he said, that Dr. Medina didn't talk about those risks. He said, no. The informed consent never should have gotten to the jury. And that, looping back into the hug instruction, that was the only basis that the judge said at that point to get it to the jury.
But you prevailed on that, right?
We did, but it tainted the whole process. You can't say that this shocking, pretty shocking as the judge said, testimony that painted him as a creep didn't infect the whole jury process. I see that I have a minute left, and I don't want to give short shrift to the very important jury of 12 argument.
If it's, just one other little question, if
Yes.
it impacted the trial as much as you say it did, why did the verdict go your way?
Pardon?
Why did the verdict go your way?
The verdict didn't go our way.
Informed consent.
We will never know. Maybe they decided to give something to us and give something to them. We don't know. We don't know what went on in the minds of juries, and we can't determine it at this point. It has to go back for a new
Well,
trial.
you just said you couldn't do that, but now you're asking us to do the exact same thing that you say you can't do.
No, I'm saying that you can't say, sitting here with that bombshell testimony, that paints him out to actually sexually assaulting a patient, that really harmed his credibility.
But doesn't the lawyer say in the closing argument that he didn't sexually assault? I mean, doesn't he go to some lengths to say, we're not saying that he committed a sexual assault or that he did anything criminal?
Once it's out, you can't undo it, you can't undo it unless a judge strictly informed them that you cannot consider this. I do want to address...
This case is not about vilifying Dr. Medina. No one is alleging that he did anything criminal or intentional. It's about negligence.
He may have said that, but we can't say that the jury wasn't affected by this shocking testimony. I do just briefly want to touch on the jury of 12.
Any other questions? Well, unfortunately, I see that's your time.
Thank you very much.
Attorney Freely.
Yes, may it please the court. My name is Austin Freely. I'm joined by co-counsel Edward Harrington, and the two of us together would ask that you affirm the verdicts in this case.
I'm going to ask you to begin. What's the relevance of the hug testimony?
Okay. Jumping right to the hug is based on looking at the context in which the question was asked. The actual question was, didn't you hug her and say she was going to look great? So it's obvious that it goes to his consciousness of liability because he wants to make her feel better about the fact that she still has high nipples after the second surgery, which incidentally he performed for free.
So you're saying consciousness of guilt?
I did not say consciousness.
Consciousness of liability.
Liability.
How does the hug show consciousness of liability? I mean,
Well,
as opposed to generally awareness that the plaintiff was upset, but that's not relevant to anything. I mean, I don't understand. It doesn't really bear on anything in this case.
Let me put it to you this way. The hug and the statements went hand in hand. I'm going to make it better. So it was the context in which those statements were made that the hug arose from. So I think we were permitted to introduce the factual circumstances under which those statements were made. In fact, he hugged her. Now, admittedly, she's not wearing clothes, as many people aren't, during a doctor's visit. So there's that level of nervousness and uncomfortability, if you were.
Well, it's certainly, I think the judge said it shows creepiness, right? It's kind of a charged thing to introduce at trial. And it doesn't, it shows creepiness. It kind of undermines the view of the understanding of the defendant in the eyes of the jury, right? It's not, and I'm not sure what probative value it offers, but it certainly, there's a danger that it offers a prejudicial value to the defendant.
Well, first of all, it happened. That's number one. And so I think the plaintiff, in telling her story, should be allowed to explain the circumstances of her story.
I understand, but reasonable minds might differ as to that. So that's why we talk about it in advance,
right?
Rather than just have it come out in the middle of a trial.
And so,
but that being said, did you initially take the position that it went to the consent factor and then switch to this consciousness of liability argument?
First of all, I think context is important. We had brought this up, obviously, in the depositions. We had brought it up on direct examination of the doctor. We had brought it up in questioning of the plaintiff. And as Justice Toone pointed out, there was another witness, there was a recess, there was a lunch break. And so then so I come back from lunch and there's a sidebar conference, and first thing I hear is there's a mistrial, motion for a mistrial.
Did you initially take the position that the hug went to the consent argument and had nothing to do with consciousness of liability? That calls for yes or no.
Well, in fairness, I wish I had another opportunity to answer at the time with the judge and what was going on. My point that I'm trying to make is, number one, we were...
To answer my question, yes or no, and then I'll let you make your point.
No. I believe that it went to consciousness of liability. Okay? When I originally asked the question 3 hours earlier, and the day earlier, 2 days earlier with the doctor, it went to consciousness of liability, obvious. The problem here is twofold. Number one, I'm confronted with the mistrial. I'm confronted with the fact that they're claiming that I never gave them notice. So at this point, I'm floored, and I'm just...
Then you misspoke?
I misspoke in terms of that. I think that's a fair characterization, because I said, Judge, it goes to consent, it goes to breach of warranty, I could go on, because at that point in time, I am totally unprepared to be responding to this. And here's the point I want to make. Had there been a contemporaneous objection back when the statements were elicited, then I would have been in a much better position to respond on the arguments about relevance, because I would have been on track. Here now, I'm on to a different section of the trial, and my focus is not on the original admissibility of something.
Understanding, you're a trial attorney. That's what you do. So you respond, and you have to be sharp. Now that time has passed, and you believe it's consciousness of liability, just once again, explain to me, because I've read the transcript, how hugging a patient and saying, I'm going to make you look great, is consciousness of liability. I mean, we know the prejudice, right? I mean,
right.
This sure is prejudicial, but tell me, because I'm missing it.
Okay.
I'm missing how a jury could properly consider hugging, saying, you're going to look great. Because I'm going to do a second procedure. Not on the first procedure. It says, hey, and you agreed to do a second one. Yes, I did. And while she was so upset there, I told her she was going to look great and gave her a hug, is what you claim. Go over that one more time, because I'm still stuck.
So in context, there was a first surgery, unsuccessful. Second surgery performed for free, along with the free tummy tuck. She's still upset. She is not happy at all. He says, give me one more chance. And in that scenario, in that context, is where the hug arose. And it went hand in hand with, you're going to look great. We're going to fix this. Hugging her as he did so. And as we point out in our brief, this was an effort.
So how does that go to consciousness of liability rather than, he just feels awful. He feels awful that he has a patient that he's trying to make happy, and it's not coming out right. And he feels bad about that.
Right, because he knows he screwed up. He acknowledges the nipples are too high. That's not in dispute. All doctors have admitted that placing the nipples too high is itself outside the standard of care.
I get it, but he says that it's as a result of bottoming out, and he's trying to fix it, and he hasn't been able to fix it yet. He feels bad.
He feels bad, exactly. And he wants her to not go on to a third party, either another doctor or a lawyer or anyone else. Look, I'm your friend, I can take care of it. That's what happened, and we believe that that shows that that's relevant to his understanding that he made a mistake.
So if we disagree with you, how does it affect the outcome here?
Well, first of all, I'd point out there was no objection contemporaneous with the testimony. So this has not been properly preserved for appeal. And that's our first contention. There was no motion to strike, no sidebar conference, nothing that could have rectified this with an immediate curative instruction. Instead, it comes up much later. I would submit that under Commonwealth versus McDonald, this whole appeal on this issue has been waived. So aside from that, there was a curative instruction. As this court knows, a curative instruction can ameliorate some harm that occurs during the course of a trial. And I would refer to the case of Bassioni versus City of Boston. And there, a plaintiff's counsel repeatedly ignored the judge's requests and instructions, yet this court concluded that the curative instructions cured the prejudice. I think the main question for this court should be this: was the jury's verdict so swayed by bias, misapprehension, or prejudice that we can't say that it was the product of rational deliberation? Clearly, this jury, which was a very intelligent jury, understood the nuances involved in this case, and they were able to apply the law that the judge instructed them on. Further, they were able to...
Counsel Reset says that while your expert Weinstein went as far as to say that it's not bottoming out and that Dr. Medina didn't take these two measurements, he didn't go as far as to say, well, by failing to take those measurements caused the high nipples.
He did say that, and I disagree with...
Where did he say that? Point to that in the record.
He said that in his direct testimony, he said...
Point to that in the record.
If we could go to the transcript, page 182 is where he testifies, and he says that that is evidence of negligence. That's negligence. He says it. And I think that's the point I wanted to make and address with this court, is that Dr. Medina wasn't faulting, Dr. Weinstein wasn't faulting Dr. Medina's methodology. Rather, he was simply saying, this is negligence. And all doctors would agree that that's a cardinal rule. You don't place them too high because you can't lower them without leaving a scar behind. He said, in addition to this is negligence, he said, to guarantee the proper way, you perform really the gold standard, which is you look at the inframammary fold, you take a measurement, you confirm whether it's mid-humerus, and then you step back and you do a visual assessment to determine where the nipples are in relation to the body habitus. There were other factors that were relevant in this case. The fact that he was late. The surgery was supposed to start at 8:37. 7:30. It didn't start at 8:37. So, given that, there's an inference that he was running late. Both plaintiffs testified that he was running late, and he did a rushed preoperative measurement. So in terms of refuting bottoming out causing high nipples, I think we spent a considerable time at trial doing just that, showing that bottoming out doesn't generally happen at all in a breast reduction surgery because the tissue is actually taken out from the lower pole of the breast.
So the evidence is that it happens over time.
And it happens over time, and it's something that no physician would warn a breast reduction patient about because it's not considered to be a known complication of the surgery. And so we didn't want the doctor to have that as an out. We didn't want him to have it both ways. So what we advanced two admittedly inconsistent theories. We said, look, it's not a known complication of this procedure. It's not. But let's say that it is. Well, if he wants to say it's a known complication, then that's something he should have warned the patient about. And he didn't do that. So you can't have it both ways. And this jury was sophisticated enough to realize, yeah, no, it's not a known complication. Bottoming out does not cause this condition, this rising of the nipples. It just doesn't. If it affects the nipple at all, it just affects the orientation, not the placement of the nipple. So I think the jury understood this. I think the jury understood the plaintiff's theory of the case from the very beginning of this trial. We showed photos and depictions of where a proper placement of a nipple would be, where an improper placement would be, and what, if any, effect would bottoming out cause on the nipple. And I think the jury understood it. I think there's no risk, there's certainly no substantial risk of a miscarriage of justice in this case. And unless the court has any other questions, I would just ask that you affirm the verdicts.
Hearing none, the matter stands submitted.
Thank you.
Thank you all very much. That concludes our business for the day. Court is in recess.
Court, all rise.
Nice to meet you. All right.